Hello and welcome everyone to our Family Law Now After Hours. Before we dive into our topic today, just a quick housekeeping items I want to make note of here to provide valuable insights on separation, divorce, and family law. Please remember that any information shared in this series should not be taken as legal advice. Today we are talking about the matrimonial home, and we'll be covering the rights and responsibilities related to the matrimonial home. If you have any personal inquiries about your specific situation, we highly recommend that you reach out to our office to consult with a lawyer or consult with a lawyer in your area. I will now begin with introductions. We have our Stephanie here. She has been with the firm since 2018. She was called to the Bar of Ontario in 2022 and is now an associate lawyer at the firm. Steph completed her undergraduate degree at Queen's University and obtained her law degree from the University of Liverpool in 2020, graduating with first-class honors. Steph, like everyone else you see on the screen, is trained as a collaborative practice lawyer, and she is committed to assisting clients through what is traditionally difficult time by approaching matters with empathy, integrity, and compassion. We have Joseph. He's an articling student at the firm. He is set to be called to the Bar of Ontario in June 2024, almost here. A graduate of the Ted Rogers School of Management at Toronto Metropolitan University, formerly Ryerson, and Queen's University Faculty of Law. As he enters the next phase of his legal career, Joe is committed to positively influencing the lives of those facing difficult family situations. Outside the office, he indulges in playing hockey and unwinding with comedy movies. We have Russell. He is the founder and senior partner at Russell Alexander Collaborative Family Lawyers. With over 25 years of experience, he uses his knowledge and expertise to serve clients in all aspects of family law and helps them cope with the difficulties of separation and divorce. Russell has written 4 books and is a fully trained collaborative practice lawyer. He speaks at conferences on collaborative practice, marketing, technology, and the law. Lastly, there is me. I'm a law graduate from Osgoode Hall Law School. I'm an articling student at the firm with plans to be called to the Bar of Ontario in June 2024. I'm focused on launching my legal career in family law. I am dedicated to providing empathic and professional legal support for those navigating family-related complexities. My experience stems from legal clinics and prior work as a legal assistant, and I am poised to contribute to the firm's commitment to excellence in family law. Without further delay, I will jump right into our topic. Today, we are talking about the matrimonial home, specifically the rights and responsibilities towards the matrimonial home. Mat Home holds a very special status in family law, and this is why it's getting its own session today in our series. We will try our best to cover as much as we can. I will get Joe to get us started on the topic. Joe, can you speak on what is the matrimonial home under Ontario law and why is it so special?
Yeah, so we've talked about the Mat Home, not so much in detail, but it's definitely come up over the last couple weeks. And the law in and of itself with respect to the matrimonial home is pretty well outlined through legislation. According to Section 18(1) of the Family Law Act, the matrimonial home isn't just any house or piece of property. The legislation actually outlines that it's any place that's owned and ordinarily occupied by the spouses and their family on the day that the parties separated. Now, this can be any type of house. It can be a condo, it can be a mobile home, or even a property that's being rented. It doesn't matter if it's jointly owned or if it's just held in title by one spouse. Now, we often hear the term, as I just mentioned, ordinarily occupied. And what does that mean? Basically, through case law, it has been defined, but it generally means that the parties are regularly spending time there. So regular spending time is what ordinarily occupied means. And as with anything in family law, what defines regularly is sometimes up for debate, and it's definitely a point of contention and it's argued between parties, but a great way to sort of differentiate it would be sort of to compare it to for example, an investment property in which the spouses would never spend, if any, at all, any time there if they were a family. So that's sort of a good way to sort of differentiate that. And another thing, there's not or could not just be only one matrimonial home. If there's another property, so if there's your main house as well as a family cottage that's frequently being used, that could also count as a matrimonial home under the law. So even if a secondary property is not your primary residence, and if it still fits the legal description, so a property that's being ordinarily occupied, it's definitely then subject to the same special rules under the Family Law Act.
Yeah, that's a really good point, Joseph. How can a cottage be a home, right? You're either living in the home or you're not. And this is a huge one. You got multiple, believe it or not, families have multiple cottages and multiple vacation spots, and they can all become matrimonial home. And it doesn't make sense to a lot of people. We only spent 2 weeks there last year as a summer holiday. How's that treated as home? But it is. So you want to be mindful of it. And we were talking last week, Seth. What was the most that we've heard of multiple homes? Were we up to 4 or 5 or?
4. I believe 4 was the largest number, at least that we've come across in case law of 4 matrimonial homes, which I would love to have that problem.
Right. Yeah. So what I hear everybody saying is it depends, right? I saw Steph smiling. I knew you were thinking of it, right? It depends. We say that every week, but it's a fact-driven exercise.
Thank you, Joe, and thank you, Russ. That's a great overview, Joe. And I think there's so much going into if there's 4 matrimonial homes, 3 or 2, is because there are these possession rights that are particular to these homes. And Joe, can you speak more on some of the possession rights in terms of the rights spouses have for living in the matrimonial home during separation and after divorce?
Yeah, so with respects to who gets to actually live in the matrimonial home and who gets to have those possession rights, it does become a bit more complicated than just who actually owns the property. So once again, we're going back to legislation, we're going back to Ontario's Family Law Act. And under Section 29(1) of that act, both spouses have an equal right to possess the matrimonial home. So it doesn't matter who's on title, doesn't matter if it's just one or both parties still have a say in who gets to stay there. Now it becomes a little bit more complicated if the home is just owned by one spouse. However, the other spouse still has a right to live there. That right does not get removed or erased. But that right is more of a personal right against the owning spouse, and that right lasts for the duration of the marriage, so up until that there is a divorce. As always, there's exceptions. This right can be extended through a court order or under a separation agreement if it's needed. But generally speaking, both parties, both spouses have a right to the home. They have a right to live there up until the divorce.
I think that's one of the most common questions that, we can get is, can I change the locks? Can I change the locks on the home? Well, if it's a matrimonial home, no, you can't, because then you can get yourself stuck in these, situations, and the courts don't take very fondly on you excluding one party unless it's, I'm sure, through a court order, which we'll talk about later. But it's definitely, don't change the locks of a matrimonial home. Do not.
That's interesting though. That's a tough question to answer, right? And my advice is usually dependent on the information I'm receiving. So, fresh dispute, somebody read a text message, their spouse is screwing around on them, there's a blow up, somebody leaves the home. Yeah, don't change the locks that night. It's too fresh. But somebody says it's over and leaves the home and doesn't call or return for 6 months. I think you might have a right of privacy. At that point, it might be reasonable to say, I don't know where those keys are. The hasn't contacted me. But if you're changing in the lock, certainly put the other side on notice, especially if they have a lawyer. You guys can usually agree to this. But you're right, Steph. And it's even more complicated if there's, incidences of domestic violence and abuse, right? And you have a duty to protect yourself and your children. And that may be a situation where you may want to call CAS, the Children's Aid Society, or perhaps even the police, and get a restraining order in place if it's that serious. So depends on the facts, right? We want everybody to be safe, and we want everybody to follow the rules, but certainly providing notice, and like Steph said, this unilateral action is not looked kindly upon the court. It depends what the facts of the case are.
Yeah, and I think that leads right in. Sorry, Shanza, for cutting you off, but I think it's a great opportunity for you to jump in and talk about getting that exclusive possession. If there is a history of domestic violence, is there a reason where one spouse should have that exclusive possession?
And maybe
Yeah.
even tell us what exclusive possession is, right?
Oh, yes. These casual terms definitely define them. But yeah, I was going to take the opening from you, Steph, because you mentioned that you don't want to just change the locks. You want to go the proper route. You want to get the court order to be able to change those locks. And there is something called under the law, which is exclusive possession. And essentially, you are asking the other spouse to leave. They're first to leave under the court order. This is something the court has the power to award, so not something you can do on your own. The court can do it on both a temporary and a permanent basis to either spouse. And this doesn't have anything to do with who's on title. Even if one spouse owns the home, the non-title holder spouse can be awarded exclusive possession if there are grounds that can justify it. Also, if you are getting exclusive possession that doesn't give you title or ownership of the home by itself, the right of possession is against the spouse and not the home itself. And there's a lot of situations where one spouse moves out of the house. Again, that doesn't give the remaining spouse exclusive possession. Moving out does not mean exclusive possession. Just want to clarify that. Now, you do need to convince the court with convincing evidence that it is something that should be granted. It's not very easy to get it. You're essentially getting the court to disregard the other spouse's right to possession, which is what Joe was hinting on earlier. If there's a lot of, I know Russ mentioned some instances, if there's a lot of conflict, if there's abuse, if it's not in the best interest of the children, they're not safe. These are the instances where you might want to go to court and argue for exclusive possession. The court will look at things like they'll look at finances, if there's living arrangements that can be made, existing court orders, all those things. And I'll note this again, we're talking about matrimonial home. These remedies are not available to common law spouses. Also, because this remedy is only available to spouses under the legislation, this means that if you're already divorced and if you have a divorce certificate, you can't claim this remedy. Is there anything that anyone wants to add?
We're getting lots of great questions coming in. Thank you. Please keep sending your questions in. But this is a hot topic, right? Changing locks, tough conversation. Just go back a moment to the cottage being a matrimonial home. There's a question if it's an investment property and they use it. Yes, I think it could be a home, but if it's an investment property, it might be an asset of the marriage subject to division. So matrimonial home has special rights to it, and occupancy rights and division rights. But if it's an investment property and you're married, it's going to be subject to equalization in any event. What if the spouse has nowhere to go? They change the locks and the police don't do anything. You got to feel for the police officers, right? They show up the home, huge conflict. They're just trying to ensure no laws are being broken and try to calm the situation. So very difficult situation for the police to be in. Want to try to resolve it through negotiation, through the other person's lawyer. If you do get locked out of the home and you've got nowhere to go, you can go to court to ask a court to deal with it. And rather than just barging in saying, I'm squatting and staying in this home, I own this home. You own the home, you have a right to be there, right? Simple as that. That's what the police should tell you. But I would prefer to get a court order on notice with a judge. That way, that's gonna protect you from any allegations of, there was damage to the property or you broke the door down or what, or, it escalates into allegations of domestic assault as well. Whether it's true or not, that's for a criminal court proceeding. We're talking about family law here. So certainly I would go to the court and ask for an order that you jointly possess the property or that you be permitted to return to the property is what I would suggest. But very difficult, especially when there's young children involved. The last thing you want is the police knocking on the door in the middle of the night and a big confrontation on the front doorsteps. It's just a terrible way to start a separation and divorce.
And I think just sort of tagging off of that, Russ, I think having a court order provides a little bit of substance for if police are involved as well. Police looking at a court order that says you have the right to occupy this home, regardless if you're on title or not, because it is a matrimonial home, like Shanza was saying. I think that goes a long way. So definitely getting a court order.
And you can put police enforcement provisions in your order. So hypothetically, you can say, officers at 52 Division are directed to enforce this order forthwith, right? The officer sees that, they don't really have much wiggle room. They're being told by the court to enforce a specific order. And you want to be very detailed in the language that you use for police enforcement.
And what about if there is an exclusive possession clause in a separation agreement, not necessarily in a court order?
Is that a topic or you want me to talk about it?
I want you to talk about it, Russ. I'm spitfire in here.
Right. Well, I don't think the police would be less likely to enforce a separation agreement than a court order. Court order has a seal as an official document of the court. Separation agreement, they don't know if somebody's tampered with it, if it's been altered. They don't know whether it was properly executed. People had independent legal advice, full disclosure, and all the rest of it. If I had an exclusive possession order in a separation agreement I negotiated for a client, and I was concerned about enforcement or that we'd actually have to act on that, I would get a consent order in accordance with those provisions. So that can be done pretty simply on a procedural motion. We call it a 14B motion. It's based on paper. But if they're consenting to it in the separation agreement, they should certainly consent to it to a consent court order. If they're not, then there's probably some mischief going on. But that's just going to give my client a little bit more peace of mind and security in knowing, yes, I have a valid separation agreement. But in addition, I have a court order specifying exclusive possession and how it's going to be executed if there's a dispute. Great question, Steph. I'm expecting audience questions, not panelist questions.
That to my defense, that was one that came in through our Q&A. I can take the credit for that one.
Okay.
So again, keep submitting your questions. We'll try to sprinkle them through as much as possible. But sorry for taking over that.
No, keep them coming. I didn't see it come in. So keep peppering us.
No, thank you, Steph.
I'm going to have more gray hair by the time this is over.
Steph is making sure they're all answered. Thanks for that, Steph. You're looking out for our audience, and that's what
There's satisfaction in hitting that button saying it was answered, right? It's like crossing off a to-do list.
Such a lawyer thing to do. But thank you so much, Russ and Steph. I think that was a very great, little segment on rights related to possession and exclusive possession. I will switch gears a little bit now, and Joe, I will put you on the stand again, and I need you to cover one more topic, and this time we're moving on to selling the matrimonial home. I think naturally after a separation, that is something a lot of people want to do. So can I get you to talk about the conditions and the process in general for selling the mat home?
Yeah, sure. So, in most relationships, the house or the matrimonial home in this instance is usually the most valued asset in the relationship. So oftentimes in order to fulfill an equalization payment or just so that the parties can start fresh and move on, more often than not, the matrimonial home is sold. And when it comes to selling or making any significant changes to the matrimonial home, there's a couple things that need to be taken into consideration. So if one spouse does want to sell the matrimonial home, both spouses need to agree on that, and it's a joint decision. If one spouse tries to sell it without the other's consent, gets a little complicated. In that case, if it does go through, any buyer who purchases the property would still be subject to the rights of the other spouse. So the one that didn't consent to the sale, or even in some cases, a court might overturn the sale entirely. And the same thing goes for mortgaging or putting any other financial burden, also known as like an encumbrance or any other charge on the home without both spouses being on board and consenting to that. Now, what if the spouses, the parties, what if they can't, agree on what to do with the home? So either spouse can go to court and ask for an order to sell the home. And that's definitely one of the ways to resolve the deadlock. And a little twist. So under Section 20 of, you guessed it, the Family Law Act, one spouse actually can register the property, and whether it's their property, if their name's not on title and just the other spouse's name's on title, or if both parties are on title and it's a jointly owned property, you can register that property as a matrimonial home without the other person's consent. It doesn't matter. And that's what's called matrimonial home designation. And that designation stays on the property record until there's either a cancellation, which can happen through a few different ways, such as a divorce decree or a court order, or until there's proof that one of the spouses has passed away. So it's not a decision to take lightly, and it's not something that just goes away on its own. Both parties need to consent to the sale of the home. And if one party does not, and both parties are on title or even not on title, a court will likely order for the house to be sold.
Yeah. The thing I would add to that, if you have to get an order for the sale of the home, be as specific as you can. Especially if somebody doesn't want, I've had clients like this and I've litigated against clients like this. Somebody doesn't want to sell the home. It's their farm and their horses are there, or sentimental value. They're never going to leave this house. This is what they've decided in their mind, right? They'll do anything. It's like stepbrothers, right? When the home buyers come over, they'll do anything to discourage a sale, take down the sign and all the rest of it. So you want to be as detailed as possible in terms of what offers are to be accepted, what cooperations to be given to the listing agent, whether or not somebody's acting unreasonably. You can return that to court to have the court decide the matter summarily. So you want to get those provisions in place if you have to go that far.
We do have a question. Someone asked, what are my options if I want to keep the matrimonial home post-divorce?
I've had this conversation a few times with several clients about, what if I want to keep the matrimonial home? I want to buy my spouse out. Unfortunately, there's no right of first refusal.
Mm-hmm.
So if one spouse wants to buy the other out, but they either can't agree on a buyout value because one spouse says the home is worth 800,000, the other spouse thinks it's worth $1 million, and they can't seem to find a middle ground or find an agreeable value. There are options. You can get opinion of values for the home. You can get the home appraised. But if it's still at the point where you can't agree and the other spouse isn't open to you buying them out, then it does have to be put on the open market. You can buy it on the open market. But again, there's really unfortunately, there's no right of first refusal, which is a very, very common conversation to have with clients.
And there's been a lot of litigation over that. I went to the Court of Appeal. So when Steph says right of first refusal, what we're talking about is here, okay, we're going to list the property, but in the listing agreement says I can buy it if somebody comes in with an offer. So somebody is $800,000 offer, somebody comes in at $850,000. The idea of a right of first refusal, you could buy it for $850,000, and then that's going to be what the sale price is. What the court found is that skews the market. people are not going to openly bid against that property knowing there's a right of first refusal, right? It's like one of these reserve bid auctions, it's a false sense of excitement. So when Steph says test the market, you're putting it on an open market, you're bidding against other offers. Some may be cash, you may be financed, your spouse, you and your agent will decide what the best offer is. And if you can't, the court will decide. Good chance you might not get that property.
Mhm.
But think of the practical implications of that. This is what I tell my clients. You got $1 million home. You might pay 5% commission, maybe more, maybe less, to your real estate agent. You have some legal fees and maybe a penalty to break your mortgage. Could be several $1,000s. So that's $50,000 to $75,000 right there. You're out of pocket even before you start realizing the sale proceeds. So that's money that can go to your children's education. Your family could take a nice holiday. You could retire debt. The more you can agree on and avoid these disposition costs, the better both you and your spouse will be in the long run. It's going to be resources and money you keep in your family. But you're right, Steph, that's a tough nut, right? If somebody wants to sell it, they're entitled to test the market.
Not even that. Some people are so eager to, go through with a spousal buyout, and then they realize they can't even refinance the mortgage on their own. So that's also a burden in and of itself. If you don't have to show at least the monthly income to be able to pay the mortgage, then there's no sense even talking about a spousal buyout.
Yeah, we'll probably touch upon this in a little bit, but when you're married, you have sometimes dual income in this pool of income to pay your bills. Now you're separated. So you got 2 homes to pay, whether you rent or buy, 2 sets of grocery bills, 2 sets of utility bills. There's not, it might have been tight when you're together. It's going to be, unless you reduce your lifestyle and scale down your home, it's going to be probably impossible, right? And for some families.
And while we're still on the topic of selling home, attendee question just came through. If one person moves out of the matrimonial home but into an investment property that both spouses still own, do both homes become matrimonial homes? If one of the properties is sold, does everything still get split 50-50 as if it was a matrimonial home?
Well, there's no special legislation in the Family Law Act for investment property, right? Yes. Sounds like somebody's up to some mischief here. Everything's an investment property. If you have renters there for a period of time, or if you live there, or maybe your home, you sublet some rooms and it's an investment property, right? Maybe you rent your basement out, or maybe you live in the basement and rent the main floor out. So I don't think investment property will trump the rules of the matrimonial home. It's not in the legislation. In any event, it's an asset of the marriage, likely, unless there's some kind of exclusion that would be hard to imagine, but there could be an exclusion. And the growth in that asset is going to be subject to division, in my view. That's a great question.
Always look at the definition in 18.1. That's what I say. 18.1 is the matrimonial home guidebook.
Joseph walks around the office. 8-1. 8-1.
No, it's just, you have to think, is the property being regularly occupied by the family?
Right. But even that definition is kind of ridiculous, right? The summer holiday at a cottage, I don't know if that's regularly occupied, especially if it's one of these 3-season properties that nobody accesses in the winter, but it still can be a home.
That's why the case law is just so abundant, right?
That's right.
But I think, Russ, you hit the nail on the head when it comes to it's still an asset of the marriage. So it still should be incorporated in that splitting of your assets, splitting of your debt process. So it should still be taken into consideration. Unless
there's an exclusion or deduction, maybe you bought it with an inheritance and kept it separate. There's
always a
depends. That's right.
Yeah.
Or common law too, right?
Yeah.
Different rules.
It's why you need to speak to a lawyer. There's so many twists and turns that you might not know exist.
Or if you want to get super complicated, the cottage could be owned by a family trust, right? There's 2 years of litigation right there, figuring that mess out. But that's a subject for another after hours. That one will go to after midnight if we get into that.
Yeah.
One. So yeah. Regarding equalization of properties from 5 years ago, to use the appraisal date, or what date to use. The magical date in the statute is the valuation date, which is your date of separation. If you jointly own a property, you can use your current value for that asset. So we can use 2 different dates. And recently, not within last year, but 2-3 years ago, these homes were skyrocketing, right? So the home could be worth $300,000-$400,000 more than your separation date. And if you jointly own it, you're entitled to share the current value. Go ahead, Shanza. I just want to get that one in quick.
Also, sorry, 5 years. There's limitations involved with that too.
Yeah.
So you got to act quick.
Yeah, agreed.
Thank you for taking that, Russ, and thank you, Steph and Joe, for answering the questions and taking over the Q&A for me. Okay, so I will now talk about, I think, Joe, you're getting me to talk about the best interest of the children. And I know we've been talking about possession and sale, and I think this general best interest of the children kind of like plays into all of the topics that we've talked about earlier and we'll be talking about later on too. So it's like an umbrella term that should always be in your mind when you're making decisions regarding the matrimonial home. So I know we were talking about possession rights and seeking exclusive possession. And if there are children, the courts will look at the best interest of the children involved. And they pay special attention to it, how a move might affect the child. They will look at the child's views and wishes, in some cases, depending on the age of the children. And that impacts the decision of whether you will get exclusive possession. And outside of exclusive possession, I know we were talking about the sale of the matrimonial home that could also be impacted. And the best interest of the children is a relevant factor when it comes to that as well. The court may decide to decline a sale request if they believe that it's contrary to the child's best interest. It has to be, so for the court to make the determination, the impact on the children has to be more than just a disruption in their life. I mean, you're getting divorced, disruption is natural, but if it can be proved that there is a negative impact on the children beyond that, and then the courts can decline to make an order if they have to. Children are a priority under our law. It's something that cannot be stressed enough. If you're separating, well-being of the children should be at the forefront. It is for the judges. Any family law matter, it is something the judges will always prioritize. And yeah, so that's my little overview on that. And I do want to switch topics a little bit at this point, and I want to focus on the financial obligations regarding the matrimonial home. And Steph, if you can speak on that and how to handle mortgage and debt when it comes to the mat home. And Steph, Russ, I'll let you say your comments before Steph
Well,
starts.
children are important. Court's not going to rush out and order the sale of the home if there's children in the home. The court's going to want a plan, right? When's the school year going to end? You're not going to uproot the kids mid-semester and move them into a different school jurisdiction in an unknown environment. Where are the parents going to live? What are parenting time provisions? We used to call that access going to look like. Somebody going to move out of province, right? So children can be a real anchor for a home. Court, there's children in the home and they're doing well and it's a stable environment. Court will be reluctant to change that unless there's a good reason. So I've seen cases where the sale of the home's been delayed up to 2 years because of the age of the children, and the primary parent didn't have the resources to get their own home or wasn't able to access the market. So I hate to say this in a strategic way, but you want to think about this when you're litigating, right? Where are the kids? How's that going to inform the court's decision on what we do with the home? Are your proposals regarding the home consistent with the best interests of the children? Now, it may not be in your best interest. You might want that house sold. You may want that capital to go buy a new home with your new partner. But that's not what the court's concerned about. The court's concerned about the children and your ability to put the children's interests ahead of your own. So when I say think strategically, you always want to put the kids' interests first and promote the relationship with the other parent. How's someone's plans to deal with the home going to inform the court as to whether or not you're making the right decisions? And that's something your lawyers can help you with, right? There's a lot of nuance in understanding how courts decide cases and what judges look at. Ultimately, on day 5 of a custody trial or parenting trial, the court, in my view, is only going to be concerned about what parent is best able and qualified to promote the children's relationship with the other parent. That's usually the tipping point. I've lost cases on that argument, heartbreaking case, and we've won cases on that argument. But that's really ultimately after 5 days of evidence, the judge is going to be asking him or herself. So all that ties back to the matrimonial home and decisions you make today regarding your recent separation and what do we do with this asset. Thanks, Shanza.
Yeah, and I think, thinking of what's in the best interest of the children and, how do you move forward with navigating not only co-parenting if there are children, but if there aren't children, your finances are so entangled when you're married, right? Not only do you have this joint asset of a matrimonial home, but you likely have a joint debt of a mortgage or a line of credit or something attached to that asset. So there's it can be tricky when you're navigating that, especially if one spouse isn't living in the matrimonial home. Often clients who have left the matrimonial home feel as if it's not fair to keep paying the mortgage or keep paying the line of credit that's attached to it. But it's important to remember that as you continue to pay this joint debt, your equity in this joint asset also increases. So the sort of baseline is to maintain the status quo. Keep paying your share of the mortgage, the property taxes, but also don't go over and above and exhaust a line of credit or unilaterally take on joint debt that's going to impact the other spouse financially. You want to keep the spending the same as it was when you were together. So those, like I said, those fixed costs of the matrimonial home, keep splitting them 50-50. But we sort of touched on it last week that the property components and the support components of a separation can sometimes be intertwined. So speak to a lawyer, speak to a family law lawyer about navigating if there's a way to, perhaps you're paying the mortgage, your share of the mortgage in lieu of, or, as a compromise for spousal support that you would have paid if you were, if there's entitlement there. So there's so many if, ands, or buts. There's so many exceptions. There's so many things to consider when navigating debt, especially debt that is attached to the matrimonial home. But my be all and end all is to maintain the status quo or discuss an interim plan with your spouse, whether it's through counsel, so nobody feels blindsided. That's the last thing that you want to do, is to unilaterally cut somebody off or unilaterally stop paying your share of this joint debt for this joint asset. So that would be my 2 cents on that.
Well, the great philosophers, Run DMC used to say it's tricky, right? So, the only thing I would add, whether or not you're in the home, you still have a covenant to the bank and the line of credit and the credit card. You want to make sure these bills are paid, because if they're not, your credit rating is going to be affected. You're going to have trouble getting a mortgage. A good legal team can be very creative in what you need. So if your goal is to buy a home, but your support obligation disqualifies you from a loan because your expenses are so high, we can lump sum part of all this spousal support payment and reduce your support payment to an amount that would get you a mortgage, and then to pay the balance in a lump sum. Vice versa. Maybe I want to buy a home, but I can't afford the down payment because I don't have the income. Well, we can jump up the support payment to get you to qualify, or jump up your down payment. We can move assets around to make sure everybody sort of accomplishes the goals that they want to get. But I agree, Seth. That was a great summary.
Yeah, great summary, Russ. And sorry, Steph. And everything, Steph, you said kind of ties into, it relates to the financials of using and the occupancy of the home post separation. And Russ, I was hoping you could speak a little bit more on some of the considerations to keep in mind around using the mat home after separation or when you're
Right.
separated.
We talked a little bit about this last week, Shanza, this idea of occupation rent. So I leave the home, my spouse is in the home. He or she is occupying my 1/2 share of the home. So I should be compensated for that. If I had to rent that home, it'd be $4,000 or $5,000 a month, whatever the rent would be. Occupation rent is tough to get and the standard is quite high. What we commonly see after, it could take several months to negotiate a separation agreement because we have to get pension valued and we need third-party disclosure. Or it could take several months to get a court order. Court orders, courts are setting dates 4, 5, 6 months down the road after the documents have been processed and served. So there's going to be a period of time after you separate, whether or not you're in the home, where it's likely, and sometimes both spouses occupy the home, right? Until there's an agreement in place. They just simply can't afford to go. Other times they have multiple homes like we talked about, or they'll get resources from their family or their parents to move on. So what we see quite common, this ties back into what you asked, Shanza, my client comes to me, okay, I've been out of the home for 2 years. How are we going to, what are we going to adjust for use and occupancy of the home? The big three that we always see, every case management judge will recommend this, property tax, insurance, capital repayments of the mortgage. Those need to be credited back to the person who's not in the home. Or even the person who's in the home. So the other thing we want to consider is whether or not there was a support obligation during that period of time. So if I'm paying all the household bills, but I also have a spousal support component, we might need to adjust for that because I'm carrying that other spouse's share of the home. So in terms of use, my advice would be just exercise some common sense. If you're going back to the home, provide notice. Usually, most temporary agreements we have in place will say, give us 48 hours notice if you're coming back and why you're coming back. Maybe they're coming back to get some clothing and we can get that ready, or they're going to get some furniture we've agreed to, right? We can disconnect the TV and get the furniture ready to go. And the more you can agree on, the better it's going to be. There's going to be less friction, less tension over the use and occupancy of the home. But those are just some practical common sense approaches. If you're not sure, make it part of the court order. If there's a nesting arrangement where you're moving in and out of the home, be very detailed as to who's going to be in the home, when, what their responsibilities are when they're in the home, maintenance, upkeep, bills, things of this nature. And the more detailed you can make the order or the agreement, less chance it's going to be an area to dispute later on. So those would be my tips.
Also, in terms of use, if there's one party that's moved out, and maybe like Russ said, you want to come back and get a few of your belongings, you've maybe left in the home and you've moved out. Oftentimes, I don't know if you've seen it too, Russ, I'm sure you have, but usually a third party will accompany that person, just to sort of be an extra set of eyes, just so there's no really he said, she said if anything does happen.
Yeah, if you're worried about confrontation or a false allegation being made, bring in a neutral party just to keep the peace. Doesn't have to be a police officer. It could be an off-duty police officer, but it could be a family friend you both mutually respect and trust. So there's usually lots of people in the community like that.
Yeah, and I just some more questions that are coming in. We'll maybe just open the floor for anyone who wants to jump in.
Rapid fire, get that Tommy
Rapid
gun
fire.
ready.
We were listening to country music in our water cooler, so I'm feeling Western today.
Okay.
So if a matrimonial home was sold, 15, 20 years after being divorced and the original spouse gave up title, does that spouse who gave up title have any right to the income to the sale of the matrimonial home?
Well, I think the court would probably hold you to your agreement if you gave up title and there's some kind of set off, or ideally the home would have been transferred at the time you gave up title. Certainly you got a limitation period problem. You have to explain why you waited 15 years to bring it to the court's attention. So I would go see a lawyer right away if you think you want to pursue a claim.
And regarding expenses, we talked about splitting expenses, those key expenses attached to the home 50-50. But what happens if the status quo was, one spouse paid the mortgage, the other spouse did the groceries and the utilities? Or what if one spouse doesn't want to pay 50-50 and is refusing to pay their share of those expenses?
Okay. You got 5 questions there.
I know.
The status quo is very powerful tool. Oftentimes your lawyers will tell you, let's maintain the status quo until we get a new agreement or court order in place. So whatever you're doing for the previous 6 months, you should continue to do. And maybe that's only going to get you from now until 3 weeks from now, until we have another meeting, and then we can deal with the immediate issues. So the status quo can be quite effective. The other part of your question is, if somebody's refusing, well, is that the status quo? Did they just never pay during the marriage, or is this something new, right? Oftentimes people are upset. They're not expecting a separation, or there's been infidelity, and they want to burn stuff to the ground, metaphorically, right? They're hurt and they're acting out, and so that could be part of it too, right? So we may want to get a social worker involved to try to understand some of the emotions and truly, in the language of collaborative practice, try to understand what their goals and interests are, right? Is your goal really to cancel the gas service to your home, right? Is that what your goal is, or are you just upset about something else, right? You cancel the gas service, you're not going to have any heat, your pipes are going to freeze, it's going to cause a bunch of other problems. So you want to dig down. Usually there's something else going on. So we would need no more information about this spouse that's refusing. Maybe that's just what they did during the course of the relationship. Maybe there's something new, or maybe, what is the reason behind the refusal? And is it something worth fighting over, right? Are you going to pay us money by the hour to talk about your Netflix bill, right? That's what, $14 a month or something. So you want to put it into some perspective and use your common sense. Did I get all? I got 2 of the 5.
Yeah, they were sort of all intertwined, but yeah, I think that was a great sort of synopsis.
Any more rapid fire? These are fun.
One sort of,
Go ahead.
sorry, one sort of going back a little bit.
And thank you everybody for the questions. They're great.
Yeah, they're amazing. They're so much fun. It's things that, sorry, they're just flying in.
Keep them coming.
So I'll just get right to it. So what happens if a spouse is not living in the matrimonial home on a regular basis? So say they work overseas, or they're traveling for work a lot and they're not physically present in the matrimonial home. Is it still a matrimonial home, even if they're not on the deed or the mortgage? But I think, Joe, were you about to jump right in?
I was, but I was gonna let you finish the question first. I was gonna let you finish your thought, and then all right.
The floor is yours.
It's like Family Feud. He's reaching for the buzzer.
Yeah. Yeah. Short answer is yes. It would still be considered as the matrimonial home. More often than not, if any property that the parties share together, even if one party's not there as frequent as the other party, if it's a home that's being shared for the purpose of raising a family, and that's where your family is domiciled, or it's where you guys are primarily living, then yes, it would still be considered the matrimonial home.
Domicile. I love that one.
Domicile.
Yeah, unless you release your interest in the home, which usually requires some kind of payment, you're fine. It's still a matrimonial home. You do want to be mindful of your limitation period, though. If you're overseas and you've been separated for several months, you're going to want to secure your rights, right, and not run out of time to make a claim.
Yeah. And one more that I'll just mention briefly is someone brought up this doctrine of unjust enrichment. So we have a very wise audience member throwing out these legal terms. I'll just sort of plug a little teaser. We are going to be talking about rights of common law couples in Ontario. And that's really when we see those doctrines of trust and equity and things like that come into play. So unless anyone wants to talk about it now, I'll just sort of plug that little teaser of, make sure to register next week for common law couples in Ontario and their legal rights.
Where is Bill Rogers?
Yeah.
Talk about common law.
Yeah.
I guess all you can really say is that if you're talking about the matrimonial home, then if you're using the term matrimonial, that means the parties are married. And I spoke earlier about the fact that regardless if both parties are not on title, the party that isn't on title still has that possessory right, and that's a personal right. So given that unjust enrichment talks about equity, that personal right would sort of tie into the same equitable principles that we don't really discuss here too often because, we only have 1 hour and we have so many topics. But generally speaking, like I mentioned earlier, if both parties were married and one is not untitled, they still do have certain rights to that property.
This is a really important audience question. I want to thank whoever asked it. Our associate lawyer, Bill Rogers, would go back to the Crusades. That's where this concept starts. So unjust enrichment is just a fancy way for the lawyers to say how we're going to share property, right? You own the home, I don't. I've ponied up the bills for 20 years and made improvements. I've got an interest in this home and you need to compensate me for it. Really short answer to a very longer question that we're going to get to in more detail. The matrimonial home, your rights are pursuant to the equalization provisions of the Family Law Act. It's another fancy way of saying this is how we're going to share stuff. You've got some stuff and I got some stuff. We want to both have the same amount of stuff. That means we're going to equalize, right? Steph's got 6 apples. I've got 4. She's going to give me one of her apples, and then that's going to be an equalization payment. You don't need to make an unjust enrichment claim because your claims are covered through the equalization provisions of the Family Law Act if you're married and you're dealing with a matrimonial home. Your common law, and you want to make a trust claim, going back to the Crusades, we're going to talk about that in an upcoming program. Maybe not the Crusades, but we'll talk about unjust enrichment.
Which is really exciting. I like all those, the equity questions.
We could, instead of cowboy hats, we'll put our body armor on.
We'll put on Bill Rogers shirts.
Maybe we'll get Bill as a guest on the show.
Maybe.
Yeah, there's an idea, stuff.
And we need 2 hours. Then we really need to extend the time.
That's right. That would be a yuck show, right? At that point, right?
We should have like in the debates where you can mute the other person's microphone if they go over the time limit.
Yeah. Start playing the music like the Oscars, right?
Yeah.
Did they play that? I didn't watch this year. Did they play anybody off the stage with the music?
They made a Matt Damon reference where Jimmy Kimmel was sort of playing fun or poking fun at Matt Damon. So every time he would speak, the sound would. I thought that was pretty funny.
Oh, it's so funny.
You'll have to get Shanza one of those buttons because I think everybody's going long here probably.
Mute, mute, mute. But no. Okay, we only have a minute left. Do we wanna, is there any more questions we wanna hit on or another topic?
Well, we haven't covered everything yet.
We haven't, so
Well, let's just press on and we'll just
Let's-
speed things up a bit. I think we're going to be, where are we at?
I
Protecting
think
yourself?
next up we can talk about, I know a lot of the underlying concern, but the topics and questions today is safeguarding your rights, so I can talk a little bit about that, and I think that ties
2
in.
minutes or less. We're doing rapid fire here.
Oh. Okay,
Take
so
your time. Take your time. I'm just having fun with you.
okay, so um yeah, so I think an underlying concern, I want to talk about the topic of protecting your interest. And I think if you are in court, and you're the spouse who's not on title, and you're worried that your spouse may try to sell the property, I think in those instances there is something called a certificate of pending litigation that you can get, and it's essentially to block the sale, like a premature sale of the house. So certificate of pending litigation it's registered on title to the property, and it's a notice. It indicates to the public that there's ongoing legal proceedings regarding the property. And what it'll do is it'll safeguard the family home, it'll protect your interest in the home and make sure that there's no dealings with the house as long as your matter is ongoing, your litigation is ongoing. This is something that a non-title holder spouse will particularly benefit from. And I know, Joe, you kind of hit on this as well. There are instances where couples they designate the home as their matrimonial home and they register that designation with the land registry office, especially if there's like 3 or 4 matrimonial homes or 2. So that's another protection of sorts. So if you have a designation, then you can ensure that the spouse who's on title cannot dispose of the property without your consent. Um, let's talk about the other side. Let's say you're the spouse on title and you're in negotiations or litigation, and it's just becoming impossible to continue to pay for the house, right? The monthly carrying costs of the house are unsustainable, they're too much. And in that case, it's inappropriate to hold off a sale and putting the family through unnecessary financial hardship. A recourse here would be to get the court to force the sale. There's a list of things, a list of factors that will dictate the court if they want to make that order or not. So these are the two sides I kind of wanted to hit on. Any comments, Russ?
Couple things. There was a question about domestic contract and excluded property. I'm going to get to the subject, but depends on the contract, right? Was it properly executed? Independent legal advice, full disclosure. Courts generally want to hold people to their word. So if you make an agreement, you're going to be bound by it. Another question about limitation period, go see your lawyer. We don't have time to deal with that today. If you're unsure you're going to run out of time, make sure you talk to a lawyer. Certificates of pending litigation are very effective. Strategically, they're effective too, right? You could force probably a better deal if somebody's got a sale that's going to fall through. Designation and title, practically speaking, I think is easier to get. I think you could just register it without a court order. Certificate, you'll likely require the certificate to be issued by the court. And in terms of forcing a sale, Partition and Sale Act's fairly clear. If you have an interest in the property, you can force a sale. Doesn't matter if the other owner, whether it's your spouse or somebody else, consents, you can get the property sold. The one break on that, or the one caveat, or the one that depends, right? Are there young children in the home? Are there other interests at play which would cause a court not necessarily to deny your request, but to delay your request? So you'll still get the order for the sale. Just might not occur until, say, June when the kids are done school. But great tips, Shanza. Thank you.
No, thank you, Russ. And I'm actually gonna get you to speak a little bit more because I think we're just talking about how so much goes into making decisions about the matrimonial home. You're selling it, you're keeping it, you're buying out your spouse. You want to plan it all out appropriately. And Russ, I would love to hear from you a little bit more on post-divorce accommodations and what are some of the planning that you want to do when you're making these decisions about the matrimonial home?
This could be an hour, but I held you to 2 minutes, so I'll get it down to 2 minutes. Like we said 20 minutes ago, you're operating as a family unit with one household. Post-divorce, you got two homes. Now there's two homes, two mortgages, two sets of bills, two tax payments. Most families will need to downsize or move to a different community to both have their same home unless they have a lot of resources. There's families like that as well. So you want to be mindful of that. What we usually do when we're in a collaborative setting, we'll have our financial planner meet with our client, and they'll map it where our clients can be 5, 10, 15 years down the road. They can predict what their budget's going to be. They can predict with fairly good accuracy what they'll qualify for in terms of a mortgage, given either support coming in or support going out, when those support payments are going to end. And you plan out ahead of time exactly, okay, here's my budget, get pre-approved, go buy the home. Those are the financial considerations. If you have children, you want to be mindful of geography. What's the school district going to be? What are the commute times going to be? How are the parenting times going to look? Who's going to be assisting with parenting? Well, one or both of you are working, right? After school, getting the kids to school. Perhaps you work shift work. Who knows, right? There's so many factors that go into it. New spouses. So you want to think, how am I going to introduce a new spouse to my children? You would want to get some kind of agreement, even dating, right? A lot of our collaborative files, we say at first meeting, what are the rules on dating? You know, is it okay? Is it not okay? When can we introduce a new partner? How should that introduction be arranged? Because these are triggers, right? Somebody brings a new partner in and they start acting like mommy or daddy. Things blow up, right? Everybody, it goes sideways very quickly. So you want to think about, you know, non-financial aspects of your move and new partners and how that's going to impact as well. So a lot to consider when thinking about your new home.
Thanks so much, Russ. I know we hit on a lot of topics today and we gave a lot of food for thought to our audience. Steph, maybe you can put some of us at ease here and tell us how us lawyers can support our audience working with matrimonial law issues.
Yeah, of course. You know, we sort of rapid fire a lot of questions, a lot of topics, a lot of ifs, a lot of it depends, a lot of exceptions. So we understand that it can be very overwhelming to navigate this on your own. And that's why lawyers are here. That's why our firm is here. That's why we put this, you know, this show on, because it's a lot of big topics that you might not have in your wildest dreams thought you would have to go through. So the big, you know, the big advice, the key thing to bear in mind is speak to a family law lawyer. If you have these questions, seek legal advice, not only to protect you, to protect your children, to protect your rights, to understand your obligations. Make sure you reach out to a family law professional. You can do that by calling our office. You can call an office or a law firm in your area.
Thank you, everyone. Thank you, Russ, Joe, Steph. You are all amazing. And it's time we wrap up. And yes, so thank you so much.
Have a great night. Great job, Shanza. Joseph, Steph, fantastic. So as always, thanks to the audience. Fantastic questions tonight. Really makes it helpful for us to understand what you're thinking. So thank you for participating.
All right. And hopefully we'll see you next week. Take care, everyone.
Tell your friends.